हमारा ये क्या जवान एक मिनट ओके गुड इवनिंग फ्रेंड्स we had been regularly taking a talk on different subjects. Today, the burning issue, political donation. Today, burning issue, new regime versus old regime, tax planning option, GST. Today, we are going to take a subject on Supreme Court judgment under Section 148E. And I have taken a 6th judgment right now to complete the एक सेकेंड ना, मैं इसको हाइड करना चाहता हूँ. Okay, so I have taken a 6th judgment of Supreme Court, which would give you a total clarity of what is section 148A, and there are I have covered everything possibly, and if anybody wants to ask a question on which is left unanswered, you can mail me. I will put on a blog all the 6 judgment as well as my PPT. In my email ID, if anyone has a question, they can come back and I'll be pleased to answer it. And at the end of the forum, at the talk, I'll keep blog open, keep opening chat open. With this, I'm going on this. I am CA Nitin Pathak, ISACA chapter. I am ISACA chapter immediate past president. And we are here to support ISACA cause. ISACA is an organization which has more than 260 branches, which is an education institution which is registered in USA, more than 260 branches all over the world, and which are very famous for information technology system and security. And this is my blog. Our update is the GST update. We have taken a last Friday, we have taken a seminar on GST update, which is available on blog and on YouTube. Our all presentation is available on channel and blogspot.com, YouTube, CA Nitin Pathak 4317, LinkedIn. Our all presentation are coming through LinkedIn, CA Nitin Pathak. You can join me in Twitter. You can join me in Facebook. You can join me on LinkedIn also. These are social media through which we disseminate the knowledge, and you can always ask me through Gmail or WhatsApp. We will be very pleased to answer this. Okay, my email ID is nitinampathak@gmail.com. My mobile number is 9825804094. Our next class would be on FEMA overview in NRI and IT formation. There are new forms coming on, and whatever changes which have been passed just few days back, Income Tax Act, we are going to take on that. CTC planning, IT notification will be available on this. This thing, I'm going again. Changes in IT form, I'm going to take on 21st. This is this Friday. Again, on Thursday, we have a talk at ONGC IRS on the subject of changes in IT and political donation, the issue. The other one, NRI formation, NRI FEMA IT compliance, we are going to take on 28th April. Now I am going to talk on the subject 149 taxman.com 123 SC, very recent judgment, which is called Income Tax Officer versus Vikram, Sujit Kumar and Bhatia. In my blog, there are 67 pages judgment which include many civil applications which has been filed before. Supreme Court. Supreme Court says that the amendment to 153C by Finance Act 2015 with effect from 1/6/2015 with respect to incriminating material pertaining to third party shall apply to search conducted before 1/6/2015. There were there were and there were a lot of cases which has arisen because of PepsiCo. PepsiCo judgment by High Court and different High Court has taken the same view, but Supreme Court categorically says that 153C applies not retrospective, but it's a clarificatory amendment. So it will apply even before search before 1/6/2015. High Court judgment was set aside by narrow interpretation belong qua patento. What Supreme Court says, the object and purpose of 153C is to address the person other than search for. Suppose HN Shuffle is having a search on that place, your document that you purchased the house, this document you find out. There is an Excel sheet found out. There are any document or papers, suppose any gold, bullion, jewelry, or any document pertinent to XYZ is found, then this law 153 is applied. 153's implication purpose is that any assessment or reassessment, if needed to be framed on the basis of search taken place X place, but on the basis of that search, the department is able to find that this person called ABC is having a transaction with HN Shuffle, and because of that, there is some addition is possible. Then this search person, this 153 is really applicable. Even as the unamended 153 proceeding against the other person was on the basis of search either of books, documents belong to or pertain to other than search person. However, it is that as in the case PepsiCo India Holding Private Limited, the Delhi High Court interpreted word belong to very respectively and narrowly, which led to a situation where though incremental material pertaining to third party or person found in the search place under section 132, the revenue could not proceed against that third person, which necessitated a legislature and parliament to clarify by substituting the word belong to the word pertain to, and the remedy the mischief that was noted in Delhi High Court judgment. And there are many courts that have taken the view. Therefore, if the submission on behalf of the respective respondent assesses that despite that the incremental document have been found in the form of books of account or document or asset in the form of gold, bullion, jewelry from the premises of such person, still they may not be subjected to proceeding under section 3 solely on the ground that such was conducted prior to amended provision. In that case, the very object of the purpose for which section 153C, which by way of submitting belong to, pertain to, shall be frustrated. Any judgment, any interpretation which may frustrate the very object of the statute shall be avoided by the court. If the interpretation is canvassed on behalf of the respective respondent is accepted, in that case, even the object and the purpose for which section 123, namely assessment of any other person, shall be frustrated. Hence, in view of the above reason, the improper common judgment and order is passed by the High Court is held to be unsustainable, and the question whether the amendment brought under section 153 of the Income Tax Act, Wide Finance Act 2014, would be applicable to search conducted prior to that in favor of the revenue and against the SSE, and is answered accordingly. Therefore, it is observed that section 153 of Finance Act shall be applicable even before the amendment come, because this is a clarificatory amendment. The impairing common judgment. Now, what they say that if this is the order on the basis of which some of the other matter which is pending before CIT appeal or at any stage, they can prefer an appeal within 4 weeks time. But this judgment regarding 153C, this would remain a law of a land. Okay. So this copy of judgment is available on my blog. After this presentation, I would put it on my blog, where I would say that 153 PPT, this PPT, as well as the judgment which 1 to 6, I would use it, including Vikas Mehta judgment, which is 66-page judgment. There were many SLP which have been I've prepared in my presentation. So 148A remains absolutely clear in the mind of anyone. The impaired common judgment and order passed by the High Court therefore deserve to be quashed and set aside, and accordingly. However, as before, the High Court respect to assessment order were challenged mainly on the aforesaid, which is now answered in favor of revenue. As above, we reserve the liberty in favor of the respective state to challenge the order before CIT on any other ground, which as applicable, it is observed in civil petition 911 with 66 taxman.com and 4 weeks time from today. The same may be considered on any other ground. Now I am discussing exact nick to nick case. The original writ petition, an individual filed a return on assessment year 1213 on 11/9/2020, 12 declaring income 44 lakh from business income from property firm. A search was conducted on 4th September 2013. A Panchnama was done on 7th September. On the basis of seized measure, assessing officer initiated the proceedings on 8/2/18 by issuing the notice under section 153C. Section 153C is equal to a search is conducted on the basis of which a document, money, bullion, jewelry, or any other asset or any document pertaining to that person is found, that that person can be subjected to assessment. If that document is used at the time of original assessment, then 148 may not be used. But if that material was not available at the time of original assessment, then 148A can be issued even though the assessment is done. The assessor filed reply on 1st May 2018 and submitted his return. While later dated 14th May 2018, the assessing officer furnished the satisfaction recorded by him and also attached there with the satisfaction note to the search person, assessing officer search person. एचएन सफल के वहां जो रेड होते उसका भी भेजा, उसने अपना भी satisfaction भेजा. From the satisfaction recorded, though it was found that no document belonging to original writ petitioner, this was found during the course of search. However, a hard disk was seized which contained an Excel sheet which contained the data on computer of such wherein there are references of the petitioner name. On receiving the detail, the original writ petitioner raised an objection to the proceeding under section 153C containing interior. What he's saying, the Excel sheet is there, which is not, like he said, Excel sheet is containing there, but it's not valid. So why I'm saying Excel sheet, data sheet, any cross-reference code would be used for initiating the proceedings and assessment under section 148, read with 153C. On receiving the details of original writ petition, Excel sheet of the data of computer of the server, wherein only reference the original writ petition name, the assessing officer could not have initiated the proceedings under section 53C as much as the condition preceding invoking that as it stood on the date of search. What they're saying, the one after 1st June 2015, and this search is taken place. This search is taken place on 14th. What is the date of search? I forget it. 4/9/2013. On the date of search, the law was as on previous year, previous date. But what are they saying? This is a clarificatory amendment. So this provision would still be applicable on 1st June 2015. The High Court have given the judgment in favor of SSE, but Supreme Court given in favor of revenue, and any assessment which is pending before 1st June 2015 on account of 153C would still be held valid. Still, the assessment officer should be satisfied any money, bullion, jewelry, or other valuable article, books, size belong to or pertain to. It was also contended that for purpose of initiating the document, independent satisfaction has to be recorded. This is an objection raised by AO and his AO, by the SSC, by the SSC of the such person, as well as the SSC of the person other than such person. What they are saying कि उन्होंने satisfaction, independent satisfaction record नहीं किया है. It was submitted that however and a particular satisfaction not recorded by the SSC officer, but it was evident that SSC merely reproduced the satisfaction. What they're saying is just copy paste. He has not applied his mind. As observed hereafter, the pre-amended section 153 belong to a person other than such person. In case of PepsiCo India Limited, interpreted belong to and observed held that there is a difference and distinction between belong to and pertain to. It was observed and held that on the basis of registered sale deed of a seized document from the premises, this is the case of PepsiCo. It was observed and held that on the basis of registered sale deed seized from the premises of such person, it cannot be sold to belong to vendor. Therefore, High Court give a very narrow view and restrictive meaning and expression to belong to, and held that ingredient of section 153 have not been satisfied. To remove the basis of observation, Delhi High Court, in the case of PepsiCo Holding, now under section 1, came to amended with substituting the word belong to with the word pertain to, insofar as the pertain to books and document concern. Thus, having found the observation made by Delhi High Court in the case of PepsiCo led to a situation though because of what Supreme Court says, though incriminating material pertaining to third party was found during the search under section 132, the revenue could not proceed against the third party. It was observed the said on the basis of observation made by Delhi High Court, and there was coming to a suppressing a very mischief which legislature intended to suppress with necessary amendment. Thus it is a case of substitution the word of way by way of amendment. In view of the above for a reason, the common judgment is made that revenue can reopen the case. That's the judgment, and they answered in positively in favor of revenue against the SSC. I have already covered that within 4 weeks, before the 4 week, any other ground they can go for. So I have covered in short. Before 1/6/2015, even if the raid is conducted and your records or documents or something is found and the initiated proceeding is pending, the case is quashed or case may be considered as judgment, and reassessment under section 148A can be done on the basis of merit. If this because of this, if any matter is to be applied on any other ground, if CID, if you want to make an appeal, you can still make an appeal before CID within 4 weeks of this date. Now this is another judgment. This is 147 Taxman 261 Supreme Court. PCIT versus Delhi International Airport. Here the notice issued SLP against the High Court that SSF, while posting the order under section 153A, read with 143 ordinarily cannot put up the assessment or reason which is in the finance unless the material gathered in the course of processing established finance contrary to the unearthed during the search. Now we are reading section 153A read with section 132, 153C. A search and seizures. High Court impugned order held that the assessment while passing the order read with section 1 ordinarily cannot disturb the assessment which were attained to a finality. What they are saying, if the assessment is final, don't touch it. But if due to 153C you found some material which is not being used at the time of 143, the material can be reopened. unless the material gathered in the course of process established that final assessment contrary to the material unearthed during the 153 proceeding. Whether notice SLB fine is in favor of revenue. Now, even if finality is achieved, but if material or something is found, AO SSC can, assessing officer can reopen the case as per 147. This is another case, okay? Well, you don't go written upset. Red Chili versus International versus ITO. I'm giving you the judgment on portal. Red Chili International Sales versus ITO, where the SSC by way of a written petition challenge the order passed under 148D along with the notice under section on the ground that response filed by SSC to the notice under section 148B has not been considered. High Court was required to examine the depth, the jurisdiction of precondition of issue of notice under section 148 and under the observed High Court in the impeachment order that writ petition is not maintainable as alternative remediable by casing the case of set aside. So if your answer is not considered by the AO, okay, then the order may be questioned, set aside, but you need not go to Supreme Court on this matter. 148A read with section 148A in escaping the assessment, conducting inquiry. What is 148 is for? Before starting a reassessment under section or reopening assessment under section 148A, conduct an inquiry by issuing a notice under section 148A. The SSA need to respond and raise the objection which were decided under section 148D. Along with the order, SSC was also served with the notice under the SSC challenge the order passed under section 148D, along with the notice under on the ground that response filed by the SSC to the notice under section is not been considered. High Court by impeachment held that where the SSC have not even been concluded by the statutory authority with writ petition should not interfere with a premature stage, and High Court exercise the jurisdiction is not warranted under article this thing. It was noted that the provision of reopening under the Act had undergone a massive change. Consequently, the judicial precondition for issue of notice would require a deeper and depth knowledge. Whether therefore observation by court in the impact order that it would not be maintainable in view of remedy was set aside and in favor of the revenue. The revenue says you can reopen now. What Supreme Court says, even if assessment not considered, you reopen, then it will be considered. This is another case. 142 Taxman.com 67. Endure Private Limited versus PCIT. SLP dismissed against the High Court order that were in of the testimony of one of the alleged supplier of the SSC that he had not carried out any transactions with the SSC were appearing in his bank account is a prima facie escapement of income was under out of and reopening the notice and SSC was issued. Such a matter was to be proceeded further. AO is right to decide the case on merit. Here AO assessment was already done, but on the basis of submission of one of the testimony of a supplier that I did not transact with this thing, which has been reflected in his bank account. Hence, on the basis of that, reassessment under 148A is permitted. Here, 69, 140, I'm going in detail. Section 69 read with section 148, 148 income tax, unexplained expenditure, bogus purchase, assessment under assessment year 13-14. SSC company has a file is returned and assessment was completed. Thereafter, the assessment was reopened by issue of notice under 148A. SSC sought revenue to reopen the income tax portal and allowed 3 working days to file a reply. However, reassessment was passed under section 148A(d). The SSC filed a petition checking the quash of order 148 impugned order and notice issued on the ground that the said order was passed relying on completely ineligible and unreadable document and without granting a sufficient time to respond the notice was in violation of natural justice. It was noted that the revenue has furnished a legible copy of document based on which reopening was initiated through the SSC at initial stage itself. It was further noted that alleged supplier of SSE had made a statement that he had not carried out any transaction with the SSE as appearing in his books of account. High Court by impugned order held that the view of testimony of supplier in the case of escapements were made out and thus matter for was proceeded further AO and was decided on merit. This was a judgment of High Court. They go to Supreme Court. Supreme Court removed the SLP and said that it in favor of revenue. This is another case. 147 taxman 261. PCID versus Delhi International Airport. Notice issued in SLP against the order of High Court that SSO while passing the order under 153 read with section 1 ordinarily cannot disturb the assessment order which is attained a finality unless the material gathered in the course of proceeding that finalize the assessment contrary to material earth during 153A. What they're saying at the time of assessment, whatever material is available with you, and during the search, survey, or somewhere, you got a document which is found, which is material and which is contrary to the document provided, and on the basis of that, some reassessment is possible, then 148 is valid. 153A read with 132, 133. Search and say assessment in case of condition by High Court of order held that assessor while passing an order under section 153A read with section 143 ordinary cannot disturb the assessment and reassessment procedure which is attend a finality unless the material gathered in the course of proceeding establish that finalized assessment are contrary to material unearthed during 153A. Whether the notice issued by SLP filed by the revenue against the imperfect, yes, in favor of revenue. In this case, you can reopen the assessment. What government says on the basis of assessment is framed and the document is found from some other sources, reopen is permissible. This is one more case. This is slightly different. This case has been won on the basis of original notice were issued on time, and the limit which 50 lakh is there is not applicable because original notice was issued in time. That's why Eastern India versus Assistant Commissioner of Income Tax. 148A read with 140 and 149. Income assessment conducting inquiry providing opportunity before issue of notice. Assessment year 2018-19. SSE challenged the order passed under section 148A(d) and issued a notice issued under section 1 on the ground that monetary requirement of limit of 50 lakh was not fulfilled in the present case, and amount sought to be added was only 34.36. However, consider precedent 2 of an asset in form of 50 was not attracted to a case when issue is noticed within 3 years of time. If within 3 years, 50 lakh is permissible. That's why even though the notice were issued after 3 before 3 years, that's why this section will not be applicable. 147, is SLP dismissed withdrawing against the High Court where the SSE challenged the order of the notice issued on the ground that monetary requirement. The notice is 148D in favor of revenue because the amount of money is lesser than that. With this, I've covered 6 judgments on 148A, and I am coming back. I'm reopening for question answer. I'm okay, now I'm here. Anyone? This presentation and our other presentation is available on the Blogspot, YouTube, Insta, Twitter, Facebook, and Insta. Okay, and LinkedIn also. Our further progress, our further seminar would be on FEMA, overview of FEMA, plus NRA provision under IT. ITR forms and changes in utility versus changes in form, changes, whatever changes in the act. I'm just major changes I would cover. Citizen planning, ITR new versus old, IT normal, which is already covered. Changes I'm going to take in 21st, 20th, I'll be taking this. Now with this, I open the forum for anyone to ask the question. I'm asking anyone to reopen this thing, unmute themselves and ask a question. Anybody want to ask a question by unmuting themselves or chat with me? Any question regarding reopen? Now reopen would be very good way of collecting revenue. Now the political donation is already started and many cases are on the verge of reopening. And it's going to be creating a havoc in the mind of this thing. I am running an ISACA chapter Ahmedabad. We are taking CISA, CSAM, COBIT, standard guidelines. ISACA is a very good course, reputed organization and all over the world. So anyone wants to join this course, most welcome. With this, I'm coming to the end of the session. And anybody wants to ask me a question, come on later on. Join with this. Thank you very much. I'm closing the session for a day. Thank you very much. This is a very short presentation. With this, I'm concluding this